Good evening. My name is Julia Abbott. I'm an attorney with Samuel Sayward and Baylor in Dedham, Massachusetts. We are an estate planning firm, and we also focus on estate administration and elder law. And tonight, my colleague Abigail Poole and I are going to speak to you about the Secure Act. But before we dive into that, I'm going to turn it over to Abby to introduce herself and kick us off.
Hi there. I'm attorney Abigail Poole. I'm glad to be joining you to talk about the Secure Act and your retirement accounts and estate plan. So I want to give you a little bit of background about Smart Counsel, which is what we're basically doing this presentation under. So our firm, Samuel Sayward and Baylor, often does quarterly presentations for our clients. Usually about 30 people can participate at our office, and we usually have wine and cheese, and then we'll discuss either our firm or our attorneys at our firm, or we will invite other presenters to come and discuss particular topics. So because of the pandemic, we decided that we would take this to the web and allow us to still educate and inform you about really important topics without having to meet in person, so that we are keeping in mind the safety of everybody involved. So without further ado, we are going to start the presentation. Thanks. So today's presentation, we are going to discuss a few different questions and provide you with those answers. So we're going to start with some of the basics as a refresher with regard to what are retirement accounts. And then we're going to move into the concepts of the law prior to the Secure Act 2020, because a lot of that law is still applicable. After that, we will talk about the Secure Act itself and the changes that it has wrought on your retirement accounts, your estate plan, and also on the people you have designated, the recipients you have designated potentially to get your retirement accounts after you pass away. Finally, what we'll do is we'll discuss what you should do with regard to all the information that you get today and what your next steps will be. All right, thanks.
Okay, so as part of this presentation, we are going to discuss what a retirement account is. And a retirement account is an account that allows you to save money for your retirement in a tax-advantaged way. And there are many different types of retirement accounts, and some of them are listed here. And they include 401ks, solo 401k, 403b, 457b, an IRA, Roth IRA, and Roth 401k, and a self-directed IRA. But for our purposes today, we are going to focus on the two sort of most common types of retirement accounts, which include 401ks and IRAs. Roth IRAs have several distinguishing characteristics, which we will definitely point out as we go through the presentation. Now, when we're thinking about retirement accounts, there are two important periods to keep in mind. One is during the owner of the retirement account's lifetime, and then after that owner passes away. So while the owner is alive, he or she must start taking regular withdrawals at a designated age. These withdrawals are called required minimum distributions. And the owner may pay taxes on the required distributions depending on the type of retirement account and how it was funded. So here's one of those distinguishing characteristics for Roth IRAs. Roth IRAs and Roth 401ks do not require withdrawals until after the death of the owner. So then after the owner passes away, the remaining balance in the retirement account will be distributed to the individual, the charity, or the entity which the owner had named as a beneficiary. The owner's selection of beneficiary influences when the withdrawals must be taken and the taxes paid on those withdrawals. Also, the owner's death in relation to his age and whether or not he started taking RMDs also plays a role. In today's presentation, we will assume that the owner dies after he or she began receiving required minimum distributions.
So I want to talk a little bit about what is a beneficiary and how is that in a little bit more detail about how your decisions now impact what happened after your death. So you have the ability to designate a beneficiary of your retirement accounts, and there's different types of beneficiaries. So you can designate an individual beneficiary, such as a spouse, or your adult children, or other family members or friends. You can also designate a charity. And finally, you can designate a trust as a beneficiary of your retirement plans. And we are going to discuss that in a little more detail throughout this presentation, because that comes into, that has significant interaction with the Secure Act in particular. So how do you designate a beneficiary? So the way you can do that is typically financial organizations will have a document that they call a change of beneficiary designation form that you can complete, so a paper document. And a lot of places also will allow you now to designate beneficiaries online if you happen to have access online. So what does that do? Essentially, you would complete the form and say, let's say a certain percentage to go to certain individuals. So for example, I have a Vanguard IRA, and I have I've listed my parents and my brother as the beneficiaries under certain percentages. So after I pass away, then they will get their share of the retirement account. So what happens if you don't designate a beneficiary on your retirement account at all? So this is a really important thing to know. And essentially what happens is that if you don't designate a beneficiary on your retirement accounts, then those accounts default to your estate. And there are ramifications for that taking place. And essentially, the ramifications are that depending on when you pass away, and if you're taking your required minimum distributions, then the estate will need to take those distributions over the course of 5 years, or under the life expectancy of the owner, that is still remaining at the time you pass away. And we're going to talk about life expectancy again in a few minutes in more detail, but I want to kind of give you a heads up about that. And this is actually called the ghost rule. And it can result in either having more time available to take those withdrawals of your retirement accounts, so more than 5 years, or it can result in even shorter periods of time. And again, we'll discuss that in a little bit more detail. Next slide, please.
Okay, so Abby mentioned the possibility of designating a trust as the beneficiary of your retirement account. And one might ask, why would I do that? And the purpose of doing that is that you would like to have a little bit more control over the distribution of the assets in your retirement account. So you may be planning for the possibility that what if you pass away while you have minor children under the age of 18 or in their 20s? Or you may be contemplating leaving assets to a beneficiary who has special needs or is receiving public benefits. If you have a beneficiary who's receiving government benefits and they receive an inheritance, that could disqualify them from future eligibility. So you might need to name a trust instead of that in order to protect their future eligibility. You may be contemplating leaving assets to a beneficiary who has creditor issues, such as collection agencies or a divorcing spouse. And finally, beneficiary could have a chemical dependency or some kind of substance abuse issue, and you don't want them to inherit the money outright. Additionally, minor beneficiaries are not able to receive assets from a retirement account under the age of 18 a conservator must be appointed on their behalf. And then once a minor does reach age 18, they could receive some or all of the retirement funds if they were designated directly as a beneficiary, which you may not want if your retirement account is substantial. I have a 21-year-old who I can't imagine receiving a sizable distribution from my retirement account right now. So I have a trust designated. So in short, the purpose of designating a trust as the beneficiary is really to control the distribution of the retirement account after your death. So I have a little example here. You would take that form that Abby mentioned and complete it. If you are married, we recommend that you name your spouse as the primary beneficiary because that results in favorable tax consequences. And then you can name your trust as the contingent or the secondary beneficiary, so that if you do pass away with minor children or beneficiaries with chemical dependency or creditor issues, that money is protected.
So you're probably wondering, or thinking, well, that's all great information, and thanks for giving me that information, but what does it have to do with the Secure Act and my estate plan? So what we want to do is provide you with a foundational understanding of retirement accounts, how they can be utilized when preparing your estate plan. And then what we want to do now is take a deeper dive into how retirement accounts interact with the law prior to 2020, so we can understand that the changes that have taken place due to the Secure Act. Next slide, please.
Okay, so here's a little summary of life before the Secure Act. The rule was that before the owner passed away, the owner had to begin taking his or her required minimum distributions upon reaching the age of 70 and a half. And that RMD, a required minimum distribution, was calculated as follows. You would take the prior December 31st balance of that retirement account plan and divide it by a life expectancy factor that the Internal Revenue Service publishes in IRS publication 590-B. And then after the death of the owner, if the owner's spouse was named as a beneficiary, the spouse could do a spousal rollover and continue taking distributions. If a child was named as a beneficiary individually, again, not a trust, but naming the child directly, he or she could take out distributions over his or her life expectancy. And this was called a stretch out. And the third option was if a properly drafted trust was named as the beneficiary, the trustee could stretch out the distributions to the trust from the retirement accounts over the lifetimes of the trust beneficiaries. So let's give an example of that. Upon the first spouse's death, so we're going to assume that the first spouse to die was the husband, was the owner of the retirement account, and he died at age 75. And therefore, pre-Secure Act, he would have been taking his required minimum distributions before he died. If he named his wife as the primary beneficiary, she can roll over that retirement account to her own account, and she would start paying the income taxes on her withdrawals from that account. Then, when the surviving spouse died, say at age 80, with remaining balances in the retirement account, and an adult son who is age 50 as the sole beneficiary, then he could start taking out distributions over his life expectancy. And again, that would be calculated by consulting IRS Table 590-B and determining what his life expectancy is. Here, the life expectancy of a 50-year-old male is 34.2 years. So in year one, he would be required to withdraw 1/34 of the value of the retirement account. In year two, he must withdraw 1/33 of the value, and the son would pay the income taxes on the withdrawals he took from the account.
So understanding the stretch out due to life expectancy is particularly important when you are designating a trust as the beneficiary. So under the law, there are two types of permissible trusts provisions that allow you to designate a trust as the beneficiary, and you will treat that trust according to the rules connected to the underlying beneficiary. So essentially, you see through the trust provisions to the underlying beneficiary. Because that's the general concept, sometimes you'll hear these types of trusts provisions called see-through trust provisions. So as I mentioned, the trust provisions must meet certain qualifications under the law. And there are two types. There's the conduit trust provision and the accumulation trust provision. And I'm going to talk about in the next slides each of those separately, because the type that is selected has ramifications and impacts your goals and wishes, along with there being taxation consequences. So also the reason why we strongly recommend that when you are contemplating what to do with your retirement plans in relation to your estate plan and selecting which type of provision might be best for you, that you work with an estate planning attorney to help you with that decision and to weigh the risks and the advantages of each option. So next slide, please. Let's talk about conduit trusts. So a conduit trust provision requires that your required minimum distributions are taken by the trustee and must be distributed to or for the benefit of the beneficiary. So that is it's full stop. So you have to, the trustee is required to make those distributions to the beneficiary after taking those RMDs for the beneficiary's benefit. So how is that practically done? So essentially, the trust will complete what's called a Form K-1 that is then given to the beneficiary to report on the beneficiary's income tax returns. So that's another key factor to keep in mind with regard to conduit trust provisions, is that if the income, those distributions, are passing through the trust to the beneficiary, then the beneficiary is the one who is required to pay the income tax on those distributions. And we want to keep that in mind because under the prior law, the required minimum distribution was determined using the beneficiary's life expectancy. So what that meant is that the required minimum distributions would be small because they'd be over a potentially large span of years. And what that then meant is that the income amount is lower and you're paying less tax on it. So a good example of the tax brackets to illustrate this is that a single person would need to have $40,000 in taxable income to be taxed at the rate of 22%. And a single person would have to have taxable income of $518,000 to be taxed the highest bracket or rate of 37%. So I want you to keep that number in mind because that's one of the big differences that you will see between a conduit trust and an accumulation trust provision. Next slide, please. So let's talk about accumulation trust provisions. So one of the ways that accumulation trust provisions are different from conduit trust provisions is that they give the trustee the decision or discretion to either retain or distribute the required minimum distributions to or for the benefit of the beneficiary. So what that means is that the RMDs would go to the trust, and the trustee could say, you know what, I'm going to hold on to all this money, or you know what, I'm going to pass this money through to the beneficiary. And that is something a decision that will need to be made on an annual basis, definitely in consultation with an accountant. So what happens if the money is held in the trust? The RMD is held in the trust. Well, what happens is that the trust is then responsible for that income and paying taxes on that income. And that has a pretty big catch, which is that when trusts are paying taxes, they hit that taxable income at about $13,000, and they're paying at the highest tax rate of 37%. So to remind you, if we were looking at a conduit trust provision, and it passed through, the RMDs passed through to the beneficiary, that beneficiary would be paying taxes when they hit $518,000 at that high 37% rate. So with that in mind, why the heck would you use an accumulation trust provision? That's a great question. So the reason that an accumulation trust provision can be very handy is if you want to make sure that you maintain and manage and control that money held in the trust for your beneficiaries. So you're essentially, a good example of that would be, I have clients who have minor beneficiaries. They have minor children, and they want to make sure that those minor children, if both of the clients pass away, the parents pass away, that the children can remain in the house where they are used to living to graduate high school or even beyond. And we want to make sure that there is money available to pay for all the house expenses. Beyond that, maybe they want to make sure that that money is protected from, let's say, creditors, such as a divorcing spouse or credit card companies. So these are all the kind of things that you have to weigh when considering what kind of trust provision, an accumulation or conduit that you want to select. And oftentimes, depending on the situation, because the accumulation trust has a little bit more flexibility, and the trustee can say, yeah, we're going to distribute the money, or no, I'm going to hold on to it. That flexibility and and maintaining the money for the beneficiaries outweighs paying that higher income tax rate. Next slide, please. Okay, so with all that in mind, let's talk about the Secure Act. So the Secure Act was effective as of January 1st, 2020. Ultimately, the purpose of the Secure Act was to essentially generate or require more required minimum distributions to be paid out over a shorter span of time, which then in turn generates more income, which then in turn generates more taxes paid to the government. So this is also, it's something that was incorporated into prior law. So the law was not replaced. It simply, they carved out and added sections to the existing law, essentially. So some things to keep in mind is, here are some of the changes under the Secure Act during the owner's lifetime. So first, and fairly importantly, they increased the date or age for when you can, or when you need to start taking required minimum distributions. So instead of it being that 70.5 years, like we discussed earlier, it's now age 72. In addition to that, they repealed the maximum age for contributions to traditional IRAs. So in other words, you are allowed to still contribute to your IRA if you are still working after reaching age 72. Lastly, they are allowing penalty-free withdrawals of $5,000 by each parent in the year of the birth or adoption of a child. Next slide, please. So here's more of the biggest changes that we're seeing from an estate planning perspective. And that really comes into play after the owner's death. So the general rule now is that beneficiaries must withdraw the balances within 10 years of the account owner's death. So that can be, they can take all of the balance in year 1. They could take 1/2 in year 5. They could stretch it out and take annual withdrawals over the course of the 10 years, or they can wait and take it all at once in year 10. So that is something that you'd again want to really work with an accountant to determine what's going to be the best option for and the impact from a tax perspective in taking these withdrawals. So again, 10 years. So keep that in mind, 10 years. So there are exceptions, however, and these exceptions are for beneficiaries known as eligible designated beneficiaries. They're called EDBs. So one is the surviving spouse. So as a surviving spouse, you can take the withdrawals over your life expectancy. So you still get that stretch out. The second exception is a minor child. So again, this applies only to a child. It doesn't apply to nieces, nephews, grandchildren, only children. And essentially, if you have a minor child, then they can take withdrawals over their life expectancy until they reach the age of majority. And it's when they reach that age of majority that they then must take it over the remaining 10 years. So there is some room for interpretation over what the age of majority means. And we are looking for guidance from the IRS with regard to that particular definition. So the age of majority might be 18, it might be 21, it might even be 26 if your child has continued their education through college and graduate school. So there hasn't been a definite answer about that. However, we're going to work off the presumption that it is age 18. And the reason I'm doing that is we want to think about what are the ramifications. So with a minor, great, they get that lifetime, that life expectancy stretch out from until they hit age 18. Then when they hit 18, they only have 10 years to be able to get the rest of the balance or withdraw the rest of the balance. So presumably they would need to have the entire balance withdrawn by the time they're 28. That might not be such a big deal if it's only a small amount of money. But if your IRAs your retirement accounts are pretty substantial, you may have concerns about having that money all go out to your beneficiary. So that is one of those interesting things to think about with regard to minor children. It's kind of an exception to keep in mind. So let's talk about the remaining 3 types of eligible designated beneficiaries. There is a disabled individual is considered an EDB and under a certain definition. And as long as they meet the criteria or definition, then they will be able to get that stretch out over their lifetime. So the definition is essentially that they must furnish proof that the beneficiary is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment which can be expected to result in death or be long continued and indefinite duration. So as you can tell, that's not the most definite in giving you some guidance. So I think that, again, this is something that will need to be clarified as we start to apply the actual act to certain situations. Maybe a good example of this could be somebody who has ALS or multiple sclerosis. So that is different from the fourth eligible designated beneficiary, who is a chronically ill individual. So a chronically ill individual can get the lifetime stretch out if they meet, again, certain requirements. And those requirements are that within the last 12 months, a licensed healthcare practitioner certifies that the person, the individual, is unable to perform at least 2 activities of daily living for a lengthy time. So an activity of daily living is something like performing toiletries, laundry, cooking meals. They have a high level of disability to the activities of daily living, or they require substantial supervision to protect from threats to health and safety due to cognitive impairment. So again, there's going to need to be some more clarification and guidance provided with these particular definitions moving forward as we apply the definitions to certain situations after an owner has passed away. The last eligible designated beneficiary is the category is an individual not more than 10 years younger than the account owner. So that would be somebody like a sibling. It could be a sibling who is older than the account owner. It can be a sibling that's the same age as, or it can be, again, a younger sibling, as long as that sibling is not younger than 10 years. Next slide, please.
Okay, so putting it all together, funding a trust with retirement accounts, post-Secure Act. So again, just to recap what Abby talked about a little bit, if you do have a retirement, a trust, a revocable trust that is drafted with conduit trust provisions, since the enactment of the Secure Act, all withdrawals from the retirement account must be taken within 10 years and distributed outright to the beneficiary. However, there is that exception for the 5 eligible designated beneficiaries, in which case the trustee may be able to take withdrawals over the beneficiary's life expectancy. Remember that the beneficiary, not the trust, will pay the income taxes on those distributions. However, if the retirement account is substantial, and everyone has a different view about what substantial is, but if it's substantial in your mind, the beneficiary may be receiving more money than you wish to be distributed to the beneficiary, and the beneficiary may be paying more taxes. Conversely, if your revocable trust is drafted with accumulation trust provisions, again, under the Secure Act, all withdrawals must be taken within 10 years unless the beneficiaries of the trust are one of those 5 categories of eligible designated beneficiaries. And then the trustee, as Abby mentioned, has the discretion to determine whether the trust will retain the withdrawals or distribute them out to the beneficiary. And again, if the trust retains the withdrawals, the trust will pay the income taxes at a much higher rate than the beneficiary would have individually. But the advantage is that the trustee, again, has the discretion to decide whether to retain or manage the retirement account distributions for the benefit of the trust beneficiaries, or distribute some or all of the distributions to the beneficiaries in any given year. So again, there is that sort of tension between the conduit trust and the accumulation trust. There are pros and cons to each, and it really is sort of client specific as to which one is appropriate. It's certainly not a one size fits all. So this is something that's really important for you to think about and discuss with your estate planning attorney. It's important to think about who you're naming as beneficiaries, whether they are minor, whether they have a chemical dependency, whether they're receiving government benefits, whether they might be going through a divorce. All of those are factors that should come into play in this discussion. And you need to discuss when it feels appropriate for you to have the beneficiary receive distributions from the retirement account. And then consider, how much money are we talking about? How big is this retirement account? And again, should the account assets be protected for the benefit of the beneficiary from situations and people outside of the beneficiary's control, such as divorcing spouses, creditors, or lawsuits?
So to circle back to one of the things I mentioned earlier during our presentation, what happens if your trust doesn't comply with the law? So if your trust is not in compliance with the law, so in other words, you have not met all of those required criteria under the law, then the distributions may have to take place over 5 years. So all of a sudden you've gone from 10 years down to 5 years. And what happens is that you now have a shorter period of continued tax deferred growth after the owner's death. And then of course that means that there are faster distributions, which means more income tax paid on those distributions and ultimately less money in the beneficiary's hands. The other route is also that ghost rule I talked about a little bit earlier. So if you recall, I mentioned that the age at which you pass away and whether you're taking your required minimum distributions impacts what happens if you're not in compliance with the law, either under the trust or perhaps you haven't designated a beneficiary. So if you have not designated, if you have died prior to taking your required minimum distributions, then again, that's when that ghost rule applies. And your beneficiary is going to be required to take the remaining balance over your remaining life expectancy, the account owner's remaining life expectancy. And that could be shorter than the 5 years. It could actually be longer than the 5 years, which might actually be advantageous for you. So the 5-year rule comes into play if the owner has died after starting to take the required minimum distributions. So keep those two types or options, or I guess I should say more so the ramifications in mind when designating or when deciding to have a trust be involved with as a beneficiary of your retirement accounts, or not naming anybody as a beneficiary on your retirement accounts. Next slide, please.
So one other option that we've not really addressed so far is naming a charity as the beneficiary of your retirement account. So we've really talked about naming a spouse, naming children, and naming a conduit trust or an accumulation trust. But one final option is to name a charity directly to be the beneficiary of your retirement account. And there are some really valuable benefits to doing this. To begin with, you, your heirs, and your estate will not pay income taxes on the distribution of the retirement account assets. And qualified charitable contributions can be deducted on your estate tax return. The full amount of the retirement account will benefit the charity, since the charities do not pay income taxes. And another possibility is to divide your retirement assets between one or more charities and some of your heirs. So you don't have to pick, it doesn't have to be an all or a none thing. You can certainly name more than one charity and name more than one individual beneficiary. You just assign a percentage to each. And it gives you the opportunity to support a cause that you care about in a tax efficient way as part of your legacy. Another option is to consider a charitable remainder trust. And this is a sort of a split interest trust. where the donor would create a trust and contribute what usually is a highly appreciated asset, such as real estate or stock, to this trust. It's usually an irrevocable trust. And depending on the ultimate value that goes to the charity, the donor would get a partial income tax deduction as a result of that ultimate amount that goes to the charity. And then the donor, the grantor of the trust, can either retain an income stream for his or her lifetime or name another beneficiary or beneficiaries to receive the income from that trust during their lifetime. And then the final, after a period of years, or the beneficiary passes away, then a charity or charities can receive the remainder of the asset. So again, that's a really nice tax efficient way to support a charity that is near and dear to your heart. And finally, another option is to contemplate or consider or investigate a Roth IRA conversion. And this is something that we would recommend that you discuss with your accountant and your financial advisor. So,
Julia is actually going to discuss a few of the recent changes that have taken place due to the pandemic and under the CARES Act in just a second. But before she does that, you probably are wondering, well, that's all great information, but now what the heck do I do? So first steps are you want to review your estate plan, and you also want to look at the beneficiaries that you have designated on your retirement accounts. And if you have a trust that's designated as the beneficiary of your retirement accounts, then it is likely that your trust must be reviewed, and it is likely that it may need to be revised to comply with the Secure Act. And to make sure that the trustee will have the ability to take the distributions over the 10 years or over the beneficiary's life expectancy, depending on what your wishes are and the needs of your beneficiaries. So you'd want to get in touch with us, and we will discuss your questions, and we will review your estate plan in alignment with the Secure Act, as well as what your goals and wishes are. Next slide.
So one final point that we just wanted to discuss a little bit was the recent enactment of the CARES Act, which stands for Coronavirus Aid, Relief, and Economic Security. So this act allows eligible participants in certain tax advantage retirement plans, including 401ks, 403bs, 457, and traditional IRAs, to take an early distribution of up to $100,000 in the calendar year 2020 without paying that 10% penalty that the law typically imposes on most retirement account withdrawals before the owner reaches age 59 and a half. This is $100,000 in total per person, no matter how many retirement accounts you have. Additionally, the CARES Act suspends the 20% tax withholding requirement that normally applies to early distributions from a 401k or any other workplace retirement plan. There is no withholding requirement on early withdrawals from IRAs. And for 2020, this is really important for some people, but not all. You don't have to take your RMD for 2020, including from inherited RMDs. From an income tax standpoint, this can be very beneficial for individuals who don't need the money because the money can actually remain in the account and continue to grow tax-free. In order to qualify to take the $100,000 withdrawal without penalty, one of the following criteria must be true. You have to have been diagnosed with COVID-19, or your spouse or dependent must have been diagnosed with COVID-19, or you have experienced a layoff, furlough, reduction in hours, or you're not able to work due to COVID-19 or lack of childcare due to COVID-19. So we welcome your questions and your comments. We invite them. And we would ask that by 5 p.m. on Thursday, May 28th, that you submit your questions and comments via email to our client services coordinator, Jennifer Poles. And her email is there. She's at poles@ssbllc.com. And we will then record a separate video to address and incorporate all of your questions and comments. And we will notify you when that is ready to view the following week. Again, we welcome your comments and your questions. We look forward to hearing from you. Thank you for tuning in to our discussion of the Secure Act, and we hope you are all healthy and you stay well and safe during this time. Abby, any other comments?
Nope. I think I'm all set. Take care,
All right.
guys.
Thank you so
Bye.
much. Bye.